Greetings, greetings, greetings. Welcome, 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 welcome. Welcome to Brilliant Babes. I'm your host, Vale Chikuni. We begin. Fani Willis. Yes, Fani Willis is not going anywhere. The case are coming fast and furious. What has transpired this time around? Well, the defendants, including the Trump team, they have filed an emotion. They want this case to be dismissed, especially they want Fani Willis to be dismissed, and they want to appeal this emotion to a higher court. Before I show you the emotion from Trump's lawyer himself, I want us to go back to how all this came about, okay, by Ashley Merchant. I found this to be very interesting. Okay, so we need to go back to the roots, okay, back to where all these things started. So I'm going to play for you a clip of Ashley when she was asked by the Senate how she came about, how she came to find out this information. Okay, so let's play a video by her. Okay. Okay. Let's fix the audio first. It's gotta be something. It's gotta be something. Something, something, something. Why don't I have audio?
But it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Ms. Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising, because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? I mean, how do you have time to represent anybody else when he's billing 24 hours a day to Fulton County?
He had other people working for him. Like, he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their like text messages. I mean, I was able to get get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say I only want text with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were remote.
Okay, so this is Ashley Merchant. Apparently, they were friends with Fani Willis and Wade. Allegedly, she's the one who approached Nathan Wade's ex-wife. Their divorce was sealed. Then once this story came about, the records were unsealed. So allegedly, it's because of her. But if that turns out to be true, she can get in trouble with that. But I was wondering, I was just like, why was her testimony, her questioning Fani Willis? Fani she was so rude to her. She was very hostile to her. So they do have a history. So I think Fani does feel betrayed. So Ashley Merchant represents Roman. Okay, so she represents Roman. And other lawyers, they have their clients in there. But they're all, I'm sure, working as a team, right? So Harold Jones also had some questions for Miss Merchant. So I want to share with you how all this transpired. I thought it was quite interesting, okay? She seems to be a character herself too, with what I have observed. So let's watch to how it came about. Here we go.
Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamans. I didn't include that. I didn't want to do the math, and I also did not want to.
How much does Ms. Willis make?
200 and something thousand a year.
So your argument is that a person who makes $200,000 a year is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip with $3,300, $4,400. And they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, if that's your argument. If that's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So, we did argue for about 3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Ms. Willis was literally sitting in at the same time. You can kind of.
So Senator Jones, walk us through.
So that hearing, that was before Judge Mcafee had ruled that there was no there. Even there's just an appearance, but they haven't established the conflict of interest as that prejudice Donald Trump. So she did have that opportunity there. That was prior. To me, that just like, okay, so you guys were still bringing this case even though there was nothing there. They're presenting their clients, right? So they have to do, they have to do whatever they have to do. I don't blame them for doing that. But it just shows you where all this is coming from. So I found that to be very, very interesting. So I was just like, okay, let's watch that a little bit. So, it didn't end there, but we can watch just a little bit more. Here we go, okay?
Argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case. So
That's
that was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture act.
Correct. But they're going to get money if they win.
Right. But there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
That's the only way they get money.
Yes.
They don't get money for bringing it.
So I just want to make sure it was clear
Right.
that was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking as far as this issue is concerned right here. When you use Whitworth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. Mm-hmm. And the prosecutor basically said no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial, so it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal stake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client.
Okay, so that's them just going back and forth, but it was kind of an eye-opener, and she was even surprised, like, wait a minute, this, Harold Jones seems to know what he's talking about. So obviously he also has a law background. So that's how all this transpired, okay? So, but now the Trump team, they have filed an emotion. So let's take a look at this emotion, okay? I want us to take a look at this emotion so we get to see exactly what they're arguing about, okay? So this is Steve Sato. He is a lawyer representing Donald Trump, okay? So this is a joint filing for all defendants, but, we're going to read. It's not long. Okay, statement of Steve Sado, lead defense counsel for President Trump in the Fulton County, Georgia case. President Trump and 7 defendants have jointly filed a motion requesting the court to grant a certificate of immediate review of its order denying dismissal. I lost my place. Okay, denying its dismissal of the case and disqualification of Fulton County DA Willis. Okay. The motion notes that the court found that Willis' actions created an appearance of impropriety and an odor of mendacity that lingers in this case, but it is nonetheless refused to dismiss the case or disqualify her. The motion further notes that the court found Georgia case law lacks controlling precedent for the standard of disqualification of a prosecuting attorney for forensic misconduct. For these reasons, among others, the court's order is ripe for pretrial appellate review. So, what are they arguing for? They are arguing for pretrial appellate review. Why? Because Judge Mcafee, in his verdict, in his ruling, said that there was an appearance of impropriety because of their relationship. However, that did not prejudice Donald Trump, so the case can go on. But to remove that appearance, either Fani Willis has to go or Wade has to go. But Judge Mcafee did not rule who should go in terms of Fani or Wade. He left it up to Fani. He left it up to Fani to decide. Either she stays or she fires Wade. So Wade resigned on his, Wade resigned before Fani Willis could fire him. So he resigned. But even though that has taken place, the Trump team and them, they're still not satisfied. That's why they are asking for the pretrial appellate review. But guess who has to approve this? The only one who can approve this is Judge Mcafee himself. So if Judge Mcafee approves this, he will be undercutting his own ruling. So why would he do that? I don't see why he would do that. Not only that, right? The case is ongoing. So you can appeal, you can ask for, for retrial, whatever, after the case is done, not before the case. I just don't see how Judge Mcafee is going to approve this. Because, if he wanted to approve this, then he would have, ruled against Fani or anything else. But according to the judgment that he has rendered, there's no there. And according to the Georgia rule, the situation with Fani does not fit disqualification. That's why she wasn't disqualified. So let's continue to read. I know there's a lot that's going on. Okay, so this is the page right here. Okay, in the Superior Court of Fulton County, state of Georgia, because that's where they filed the case. Case number right there, state of Georgia versus Donald John Trump, Rudy Giuliani, Mark Randall, Robert David, Michael A. Roman, that's the one that Ashley Merchant is representing, David James, Harrison William, Prescott Floyd, and Catherine Alston Lethan, defendants. Defendants' joint motion for certificate of immediate review. Defendants President Donald J. Trump, Rudolph Giuliani, Mark Meadows, Robert Cherry, Michael Roman, David Schaefer, Harrison Floyd, and Catherine Witham filed this joint motion for a certificate of immediate review and request that the court grant a certificate of immediate review of the court's order on defendants' motion to dismiss and disqualify the Fulton County District Attorney issued March 15, 2024. The March 15 order to the Georgia Court of Appeals pursuant to OCGA S56-34B. The March 15 order is of exceptionally great importance to this case, substantially impacting defendants' rights to due process. Additionally, given the lack of guidance from the appellate courts on key issues and the fact that any errors in March 15 order could be structural errors that would necessitate retrials, the grant of a certificate of immediate review is both prudent and warranted in its order. The court found the District Attorney Willis' actions had created an appearance of impropriety and an odor of mendacity that lingers in this case as well. So it's a 9-page motion. We're not going to read all of it over here, but that is from, that's the motion that was filed by the defendants, including Donald Trump himself. So we're going to see as to what exactly is going to transpire. But I just don't see how Judge Mcafee is going to approve that. If Mcafee does not approve, then the case will go on because he's the one who is the sitting judge who has to approve this. Remember, whatever was happening was just a hearing for misconduct. So according to the ruling, the hearing was not dismissed because there was no, there was no there, okay? According to what has happened, regardless of what everybody else thinks. But these are the lawyers. What? They have to defend their client. They have a right to do so. So there's quite a lot that's going on. Donald Trump was unable to secure the bond of $464 million civil fraud judgment that's going on in New York. Nobody wants to lend him money. Now there's bloodbath gate that is going on. So there's cases everywhere. Welcome to 2024, the year of election. So let's continue to listen in to what has transpired. Okay, so this is going to tell us. Okay, so this is just a wrap up of everything that has taken place in terms of this disqualification situation. So let's listen in.
Just in the last hour, attorneys for former President Donald Trump and several of his co-defendants asking Fulton County Judge Scott Mcafee for official permission to immediately appeal Friday's disqualification ruling.
And that ruling allowed District Attorney Fani Willis to stay on the case as long as Special Prosecutor Nathan Wade stepped down. But attorneys for the former president and his co-defendants say they aren't satisfied. They say Willis should have been removed too. And now they are asking for permission to make that argument to Georgia's appeals court.
11 Alive's Grace King explains how this could affect the timeline of the case.
The issue with the appeal is whether the case goes on in the meantime behind the scenes.
On Monday, a new motion asking Judge Scott Mcafee to allow for an immediate review of his disqualification order. Attorneys for the former president and 7 others say the judge's decision is one of exceptionally great importance, where ensuring the appellate courts have the opportunity to weigh in on these matters pre-trial is paramount.
Is the issue so big that the case literally can't proceed at trial until it has been ruled upon by the Court of Appeals?
Criminal defense attorney Joshua Schiffer tells 11 Alive that Mcafee must decide whether to let the defendants appeal now or later.
He can basically say, go appeal this later. It's not something that actually affects this case. It's something that's important. It's something we need to go into. It's something that needs to be explored. But the needs of trying this case now outweigh the importance of what could happen to it later.
Schiffer says the judge could approve this motion or deny it based on the number of other appeals expected in a case of this magnitude.
There's a strong argument for efficiency's sake that we should just put all of those appeals together after a trial, rather than trying to piecemeal these complicated issues one by one in advance of a trial, because that would push the trial back months and/or years.
In Fulton County, Grace King, 11 Alive News.
And of course, we are.
Yes. So, yeah, I know a little bit something over there. Like, no, you let the case go on, then you can appeal after the fact. It's in their interest to delay the case, right? Because, the more you delay, the better it is for your clients. Okay? These are the tactics that the lawyers use. But Fani wants to go get this thing done with. So I just don't see how Mcafee is going to approve that. So if Mcafee doesn't approve, then the case will go on. I think that's exactly what's going to happen. But there is an incoming that's coming from all angles as far as Fani Willis is concerned, because now in Georgia, Governor Kemp has just signed into law, I think immediately, effective immediately, they will have, I'm paraphrasing, they will have like a panel of 8 people who are going to be overseeing, like the police over the DEA, over the DA. That way, they're doing their job up and up. So they're going to, if people have complaints, things of that nature, they will have the authority to investigate a DA. They'll have an authority to remove the district attorney. So That's what Governor Kemp has implemented. But because in order for somebody to be a DA, people vote you in office. So if you get to be voted in office and these 8 people have the power to remove you from office, even though people have voted you into office, I don't know how that's going to work. I guess they have to impeach the DA. I don't know. But that has already been signed into law. And another citizen has also filed a complaint with the bar against Fani Willis. So far, Fani Willis has a bar complaint pending. Now there will be other eyes on her who can sue, remove, and then you have this motion that has been filed. And who knows what else is going to be coming out of the woodworks. So yes, Queen Fani Willis survived the misconduct hearing, but it looks like there's more targets coming. So far, Fani Willis hasn't issued any statement. She hasn't said anything. Ever since the ruling, she just remained quiet. The only thing that came out of her office was responding, accepting Nathan Wade's resignation. But the story is unfolding and it's definitely ongoing. But stay tuned because there will be more coming. All right, guys, that is all that I had for you guys today. I hope you find this to be informative to you. Be sure to subscribe to my channel. Follow me on Instagram, Facebook, and Twitter. Until next time, remember to be in the know. Thank you.